Well, good afternoon, everybody. Welcome to this King's Court of Protection seminar on emotional dysregulation, the use of anticipatory declarations in the Court of Protection. And I'm really quite excited about my panel today. It includes my esteemed colleague, Ashley Campbell, who will be giving us an outline of issues relating to fluctuating capacity in terms of legal framework and anticipatory declarations. And our external panelist today, Dr. Nicholas Todd, who's a consultant clinical psychologist, will be giving his perspective in relation to emotional dysregulation. As some of you may be aware, Dr. Todd is a consultant clinical psychologist specializing in learning disability and autism. And also, I found out today, sits as a specialist member of the first-year tribunal in the mental health division, which I think is a new thing since I last met him in a case in which he was giving evidence about emotional dysregulation. So welcome to both of you and welcome to everybody. This is a vexed topic and we are going to be discussing quite interconnecting issues as to what emotional dysregulation is, whether it fits into fluctuating capacity, how the court manages it by way of anticipatory declarations. We'll give you a bit of a case example as to where it may fit into in a specific factual circumstance, and give you some practice and procedure guidance in terms of what to do in these cases and how the court manages these very difficult cases. So I'm going to start off by inviting Dr. Todd to give a short presentation on emotional dysregulation, what it means, and what it's really all about. Dr. Todd.
Okay, thank you very much, Sam. This seems a very hot topic at the moment. I'm involved in a number of cases where this is a real central feature at the moment. So I'm just going to take you through a bit more of a definition of what this means, what is emotional dysregulation, and then talk about how we go about assessing it and some of the issues there. So if we just think about what emotional regulation is first. So it's the ability to attend to and understand our emotions, the propensity to respond to emotions in a helpful way, the ability to maintain cognitive and behavioural control when we're experiencing emotions, and the perceived and actual ability to control our emotions. So that's emotional regulation. And I'm now going to talk about the difference, the opposite to that, emotional dysregulation. Next slide, please, Sam. So it's very much an umbrella term that includes all sorts of different things. And there's actually been two main academic theorists that have tried to explain all the things that might come under this definition. And Jill et al. Have actually created a measure, like a questionnaire that you can do with patients to look at whether they're experiencing these things, which it looks quite helpful actually. So this includes things like having a detrimental attitude towards your emotions or a non-acceptance of your emotions. So kind of denying that they're there and not really paying attention to them. Not really being attuned to your emotions, not having much clarity about them or awareness of them, having low emotional control when you experience them and have impulse control difficulties, reduced attention and reduced behavioural control. And crucially, you don't have the regulation strategies to deal with these things. You might engage in avoidant, externalizing or internalizing coping strategies instead. Internalizing might be things like self-harm. Externalizing may be things like engaging in risk-taking behaviours. I'm sure lots of you have seen people who engage in those sorts of things. And people who are experiencing emotional dysregulation can also experience difficulties with goal-directed behaviour as well. So they struggle to go through life in the way that they want to, and they get very caught up in things. So people could be experiencing one of those things or all of those things to be deemed as experiencing emotional dysregulation. Okay, next slide please, Sam. So it's a core symptom of a range of psychiatric disorders. So it can be considered a kind of transdiagnostic feature really in a range of things. So learning disabilities, autism, personality disorder. post-traumatic stress, ADHD, bipolar, and also substance misuse disorders as well. So I think where it's most commonly seen would probably be personality disorder as a very clear symptom, and autism as well in my practice. Next slide, please, Sam. So there's also people who don't meet necessarily a diagnostic category, but may still be presenting with emotional dysregulation. So these might be people who have experienced lots of psychological trauma in their childhood. So stuff like emotional abuse, physical abuse, witnessing domestic violence, bullying, adversity. And this affects the quality of the attachments they form as a child, causes them to create a negative view of themselves, difficulties with their identity, which causes problems with regulation of their emotions because they don't learn how to do it. They don't have people to show them how to do that, and because they don't have a stable identity, they're more prone to experiencing emotional dysregulation problems. So you may then have emotional dysregulation problems and need to use survival strategies, coping strategies, in order to get through life, and they may be risky. Okay, so that this is just to show that you don't have to necessarily have one of those diagnostic categories to be experiencing emotional dysregulation. If we go on to the next slide, please, Sam. So is it an impairment or disturbance in the functioning of mind or brain? I've been cross-examined on this a few times, actually. And I would very strongly argue that it is, because it has very clear cognitive, emotional, behavioural and physiological symptoms. And if they are impairing your functioning to the point where you can't work, or you can't engage in hobbies, you can't form friendships, you can't do things that ordinary people may do, then it can be considered an impairment. And because people like biology and the brain, when we're talking about mental health sometimes, this also has a very clear neurological basis as well. So you'll see this diagram over here. When people are experiencing emotional dysregulation difficulties, the emotional part of their brain, that middle bit, is firing rapidly. So the front of their brain, the judgment part of their brain, is turned off. Okay, so that's a really basic kind of explanation of what can be going on. So someone is operating completely from an emotional place and not a rational or wise place. So to me, very clear an impairment, but you do need to be a skilled mental health practitioner to assess the presence of that. And just because someone gets a little bit upset or gets distressed in certain contexts doesn't mean that they have emotional dysregulation difficulties. So I think this is where deferring to an expert on these issues can be really useful, I think. Next slide, please, Sam. So the causative nexus is another issue. I think it's very difficult if you don't have a good understanding of how the emotional dysregulation operates. So what are the factors underlying it? Because if you don't have that, you can't really link it to the functional test. So the first thing, the reason why we need that understanding is it could be that support could be offered to reduce it in the first place. So it might not even be an issue. If we can work out why it's happening, we can reduce its presence, and then it might not actually be affecting the functional test. The other reason why it's important to have that understanding of the underpinning factors is because we need to know if it's an unwise decision as well, or an incapacitous decision that the person's making. It could be incapacitous if the person is operating in a way that's very clearly related to the emotional dysregulation, but it could be unwise if it's completely unrelated. So I think this is where, again, having an excellent understanding of the proper understanding of how this operates helps. So it's not very simple, this causative nexus bit. Next slide, please. Okay, so this is just a little example of how I might do that really simply for a court, to try and explain a psychological formulation of how emotional dysregulation might operate. So for someone I worked with, their core emotional pain was around rejection, and that was what triggered anything that triggered their rejection is what caused them to go into a period of emotional dysregulation. So this person engaged in all sorts of coping strategies here. So seeks care from anyone that will provide it, but unfortunately those people then take advantage of her, so she feels even more rejected. She might self-harm and go to hospital kind of discharge very quickly, so she feels rejected again. She might turn away carers before they reject her, but then she fails to develop healthy attachments, then she feels more rejected. So this is what was going on for this person. So I could establish that if she was doing these things to do with her coping strategies, like seeking care from anyone who can provide it, turning away care, or going to hospital in that sort of context, that the decisions she's making there may be driven by an emotional dysregulation, because I've worked out that's what how her emotional dysregulation is working. But any other things, they may not be affected. Any other decision may not be affected. Okay, next slide please, Sam. So the next thing to think about is the fluctuating nature of this. So by its very nature, emotional dysregulation fluctuates. Some people experience periods of emotional dysregulation followed by periods of regulation. Other people experience different levels of intensity of emotional dysregulation, but by its virtue, it generally fluctuates. Okay. So for me, it's fluctuating if the person cannot use and weigh the relevant information when they're emotionally regulated, but they can do it when they're regulated. Okay, but the next bit for me is very important, that they have to be able to understand that when they become emotionally dysregulated, that they make decisions they wouldn't ordinarily make, and they can weigh and use the consequences of continuing to make those decisions without support, with the benefit of support to manage those periods. Because if you've just got the first bit, it could be argued that they don't have capacity, their capacity isn't fluctuating, because if they can't understand or use and weigh their emotional dysregulation, then it's different. So I think that for me is the important bits. Okay, so Sam, next question. Right, people might have seen this kind of conceptualization before, the kind of 3 ways that capacity may fluctuate, and I've just come up with some ideas of what might happen in emotional dysregulation. So there may be people where it fluctuates temporarily, so there might be a major life event which they can't process very well, but then after they do process that, they return to baseline, so they're back to normal. It may be that, I think this is the most common for me, fluctuating on a predictable basis. So specific triggers that can be identified in the person's formulation. So particularly with people with autism, where there may be very specific triggers around change that may cause a period of emotional dysregulation. Or the lady I just mentioned where it was all about rejection. And these are the most difficult, people where their emotional dysregulation is occurring at random without any warning. So I think all these 3 different types of fluctuating capacity would need very different management by the court. So I think that's where I hand over to the legal experts now on how you manage this really challenging situation.
Yeah, thank you, Doctor. I'm just not going to release you just quite yet. And in similar vein to the questions I've asked you before, if I could just take you back to this slide, which is where you demonstrate that it could be a core transdiagnostic, which sounds quite a fun term, symptom in the range of psychiatric disorders, and you list some of them. Is it right then to think that emotional dysregulation is a symptom of any of these diagnoses, or are we in a situation where an individual could have emotional dysregulation just by itself, and that in your view, can amount to an impairment, or is it that it's always attached to something else?
No, I think it very much can be standalone, because not everyone will be diagnosed with something. So people who've had lots of trauma, for example, may not quite meet the threshold for personality disorder, but they still have emotional dysregulation that is affecting their functioning in very significant ways.
Yeah. And would you say that it's something that's, I mean, the concept of emotional dysregulation, I'm just thinking aloud here, is something that's evolved in terms of its clinical research and being used by clinicians like yourself. And it's kind of a good example of how perhaps a case like the one you've given 10 years ago, if it got to the Court of Protection, the conclusion may have been that the person lacks capacity throughout time, whereas now that conclusion may be a bit nuanced. Is that a fair description?
Yes, I think the court has also evolved to not just see people as diagnostic labels, that it's a lot more complicated about what's going on underneath. So I don't want emotional dysregulation to almost become like a diagnostic label. The court's been very good at digging into these labels, hasn't it, and working out what part of that is actually causing the person to lack capacity. And that's where a formulation of their difficulties can be really useful to explain to a court why, what bit. Yeah. And I think that's been the benefit of working in the Court of Protection, that's always been accepted as a very useful way of working, to work out how things are related.
Yeah.
Whereas I think in the Mental Health Act, there's a very strong focus on it being a disorder. Whereas in the Court of Protection, it's a lot more clear that it can be any impairment or disturbance, as long as it can be demonstrated as such.
Yeah. Super. Thank you, Doctor. That's been very, very useful. Before I hand over to Aisling, where she's going to outline the legal framework of how we grapple with these cases, or how the court grapples with these cases, I thought it'd be useful just to have a bit of a factual scenario to see how emotional dysregulation can bite and how the court deals with it. So Alex is a 20-year-old individual. He lives in supported living accommodation with 24-hour care. And he has a diagnosis of autism principally, and then emotional dysregulation on occasions. And the evidence that the court has is that when he is emotionally dysregulated, and there are times which are defined for him when he is emotional dysregulated, for instance, when he's not getting his way with care, or he's in an argument with his girlfriend, that is a time when he can become emotionally dysregulated and may lack capacity. So if that's the factual scenario, tell us, Aisling, how on earth does the court grapple with this?
Well, the starting point really when considering fluctuating capacity is the Mental Capacity Act 2005, and I've highlighted there on the slide the main provisions that anyone would want to turn to, I think, as a starting point for fluctuating capacity, and particularly at section 2.1, the fact that a person lacks capacity in relation to a matter if at the material time he's unable to make that decision for himself. And also the court will have to bear in mind that it doesn't matter whether the impairment or disturbance is permanent or temporary. So that's the statutory background. There's then on the next slide the provisions that we feel are relevant from the code of practice accompanying that act, so 4.4, 4.26 and 4.27 in particular. Again, they really focus on the time that the decision is going to need to be made, and helps a little bit with a definition really of fluctuating capacity, which is a problem or condition that gets worse occasionally. There's also on the next slide some paragraphs from the Dole's Code of Practice that we think are helpful as a background to the fluctuating capacity legal framework. Those paragraphs 8.22 to 8.24. Really, I think the interesting bit is the section in bold at the end of 8.24, where the regaining of capacity is likely to be temporary and the authorisation will be required again within a short period of time. The authorisation should be left in place, but with the situation kept under ongoing review. So that, I think, is a very interesting background to how we deal with fluctuating capacity when we've got standard authorisations in place. But there's also a legal framework behind anticipatory declarations, sometimes called contingent declarations. Again, starting with the Mental Capacity Act 2005, Section 15 really is the gateway to anticipatory declarations, because it says the court may make declarations as to whether a person has or lacks capacity, but also as to the lawfulness or otherwise of any act or an act yet to be done. So that seems to be the provision that the courts attach anticipatory declarations to and derive their power from, because it's not curtailed in the same way as Section 16 is. Because Section 16 says this section applies if a person lacks capacity. That takes us back to Section 2 and imports the wording of if at the material time. So the way it's been interpreted in the case law is that we don't have the power to make anticipatory orders because of the wording of Section 16, but that there's nothing beyond the statutory intent to read that into Section 15 with declarations. So beyond that, we have some case law that really starts with more of a family case, Reed D from 2009. Anticipatory relief was granted in that case that would come into effect upon the birth of a child. And really the emphasis was on how exceptional the circumstances needed to be for that to take place. Probably the next significant case after that is the ABC one before Mr. Justice Headley, and that was the start of his longitudinal view that Sam's going to go on to talk about. Essentially, he called it qualified capacity in that case. He didn't make a declaration that P lacked testamentary capacity, but said that needs to be strongly qualified. There will undoubtedly be times when he does lack it, and those times are likely to become more frequent. So you're going to need contemporary medical evidence asserting capacity if you want to rely on the exercise of that capacity at any point in time. And now Sam will go on to explain, really that's the start of framing the question of capacity differently, essentially depending on whether it's a one-off decision or ongoing decision making. In the CDM case, though, Mr. Justice Cohen didn't really adopt that school of thought. He said fluctuating capacity causes problems, and the options open to the court include refraining from making any declarations at all, or providing a plan to determine capacity from time to time. And he said the court did have a duty to declare if somebody had fluctuating capacity. In that case, he accepted medical evidence that when making appropriate decisions, P had capacity, but when making manifestly inappropriate decisions, she lacked it, and then made a declaration of fluctuating capacity, relisted for a hearing to establish the mechanisms under which the local authority would operate. But then the ball went back into the court of Mr. Justice Headley in the PWK case, and again he reaffirmed his longitudinal view to avoid the difficulties that he said were presented by making declarations of fluctuating capacity. He said those were twofold. Number one, he queried whether the statute actually permitted a making of a declaration in those terms. And number two, he said that there's a practical problem of how those responsible for P's care could in fact operate such a declaration on the ground. In the next case, CD, that was before Mr. Justice Francis, another childbirth case, which I'm sure as you research into these cases, you'll discover is rather a prevailing theme. And he did grapple with that problem identified by Sir Mark Headley in the PWK case. And he said it is section 15(1)(c) that gives the court the power to make an anticipatory declaration of lawfulness contingent on P lacking capacity or losing capacity, again in exceptional circumstances. And he reinforced that because of the wording of section 16, the court isn't empowered to make an order before incapacity is made out. Then in the DN case, before Mr. Justice Cobb, actually we saw a move away from the exceptional circumstances surrounding unborn children and childbirth decisions. P was a fairly ordinary court of protection P, in the sense that the decisions that needed to be made were just residence and care ones. He had what was described as meltdowns by reason of autism, anxiety and poor emotional regulation. I'd be interested to see what Dr. Todd's assessment of P would be in that case with his expertise on emotional dysregulation. But perhaps the most curious part is that Mr. Justice Cobb was prepared to make anticipatory declarations, but he did so under sections 15 and 16, which seems odd when section 16 doesn't grant the power to make declarations in any event. But he said that those declarations would provide the legal framework for the care team, ensuring that any temporary periods of deprivation of liberty were duly authorised. And he tagged on the end that that would protect the local authority and the care team from civil liability, which I thought was an interesting take on the circumstances, given that we're always supposed to be focused on P's best interests. I mentioned the NK case just very briefly, because Mr. Justice MacDonald refused to make an anticipatory or contingent dole order, essentially because it was too far removed from that being put in place for a child. And then there is Mr. Justice Hayden's decision in the R case. He reluctantly made a declaration that if P lost capacity, it was lawful for the NHS Trust to deliver obstetric care to her, even if that obstetric care didn't accord with her clearly stated and capacitous wishes and feelings. The way he kind of reconciled that, I think, with his own views about what was going on, was that he said that childbirth is a dynamic process, labour is a dynamic process, and people often change their decisions as part of that. And P wouldn't have the opportunity to change her view on the obstetric intervention if the declarations weren't made. And the declarations being made would mean that there was a range of obstetric treatment options open to her when she went into labour. And I've highlighted there paragraph 35, which I really think is the hallmark of the latest anticipatory declarations case law. Two final cases that came before Mrs. Justice Leven. She dealt with fluctuating capacity in the context of dialysis treatment in CC, and again was prepared to make a declaration that when P had capacity and wanted when he wanted dialysis, he had capacity, but when he refused it, he lacked it. And perhaps that was a slightly easier case because he did actually want to receive dialysis. It was when he lacked capacity that he didn't. And then in the KK case, again, Mrs. Justice Leven accepted the evidence about prospective loss of capacity, but she didn't make anticipatory declarations in that case, essentially because she decided they were going to serve no purpose on the facts. So that is a whistle-stop tour of the cases that you may want to refer back to when looking at people like Alex.
Thank you, Aisling. That really was a tour de force of the statutory framework, which allows the court to make declarations, be it anticipatory declarations or contingent declarations, or declarations when someone lacks capacity, when their capacity fluctuates. So thank you very much for that. I think the only thing I'm going to add is in relation to this, which is the longitudinal view and perspective which you touched on. And the case of Dunhill and Bergen is a good example of that, because what that case demonstrates is that you can separate, or at least the courts have demonstrated, you can separate self-contained, and these are the court's words, self-contained transactions, so ones which are made in isolation and relatively abstract, compared to those which are a series of linked decisions. And that's exactly what the court said and referred to in the Dunhill case, where it said that the proceedings themselves may take twists and turns. And I just stopped there, that this relates to someone's ability to have capacity or to lack capacity in relation to conducting proceedings, and may develop and change as the evidence is gathered. and arguments and refined. There are, of course, litigants' capacity fluctuates over time. So there are many times in proceedings where a litigation friend and other times when there are not. So just demonstrating there can be twists and turns and a series of decisions that need to be made in a litigation. And if someone's capacity goes up and down consistently, then the court could see in those circumstances a benefit for a litigation friend, i.e. that they lack capacity, or at least took the view that they lack capacity to conduct those proceedings. And you touched on the Cheshire West case, the PWK case of 2019, which relates obviously to the management of property and affairs. And there the court clearly held the view that because the management and the specific management of this P's property and affairs was so unpredictable that it required P to be engaged consistently. And the evidence was that the individual wasn't engaged consistently. And what I mean by that is that their capacity fluctuated up and down. So in those circumstances, the court decided that P lacked capacity to manage his finance. You can apply that, as I've done in other cases, in respect of not so much residence, but especially in respect of care, because you can see a set of circumstances where someone's care needs are relatively complex. And if their capacity fluctuates, then there may be an argument that they lack capacity generally, because there's a series of linked decisions to make decisions about their care. Okay, well, that really takes us to the end part, which is practice and procedure. So having just taken stock, having heard the clinical perspective, which is that in some cases, emotional dysregulation is a symptom or a manifestation of some other underlying disorders, but actually could be a freestanding impairment or disturbance of the mind. And having seen the statutory framework and the case law that backs it up, how does that actually transpond and translate to an order that can protect P? Well, it comes essentially to this, that there could be anticipatory declarations. So for instance, Alex, for instance, the expert could be asked to clearly define the circumstances when Alex is emotionally dysregulated, the duration, when it happens, how it happens, and how long it lasts. And if that evidence is clear, and obviously you need to put those questions to the expert to determine the nature and the frequency of incapacity, but if that evidence is clear, then you can ask the court to make anticipatory declarations that in highly specified circumstances, so for instance, when Alex is emotionally dysregulated by reason of falling in an argument with a partner or disagreeing with care staff in respect of various decisions, then in those circumstances, he could lack capacity. But that's not the end of it. There plainly needs to be a reassessment of his capacity at that particular time. Otherwise, that kind of order would be quite draconian. And so if there is a reassessment and a conclusion at that particular time that Alex lacks capacity to, say, make decisions about his care and residence, the order could provide for him to be taken to a place of safety. And that place of safety could be a place which is governed by a standard authorization, and in which case you don't need any further orders because an urgent authorization can be put in place. But if it is a place which isn't governed by standard authorization, then the order can go a step further and deprive their liberty for a period of time. The central part of all of that is that the evidence, which is also crucial, is how long that period of emotional dysregulation lasts for, because it can't be indefinite because it only lasts for a period of time. And the evidence that you'll have to obtain from the expert is really, has to fine tune in terms of the indicators as to when the individual is going to regain capacity, and fundamentally what you can do to promote their capacity in those circumstances. And then once they've reached that point, a further assessment, and if they're in a placement which Schedule A1 applies to, then the urgent authorization or the standard authorization is discharged. It is a bit of a revolving door, and that's a term which many of the courts have used in when talking about fluctuating capacity and anticipated declarations. But in fact, on balance, it probably achieves a situation where P's personal autonomy is promoted, and the statutory bodies have the opportunity to protect them when they are emotionally dysregulated. So that's how it all comes together. I don't know if Dr. Todd and Aisling, whether you wanted to add anything to that, but that seems to me to be the kind of the general way where we can glue all things together, and then the court protects P to promote their, well, protects them as well as promoting their autonomy.
I have nothing to add. I think that was a masterclass, Sam. Thank you.
I think for me, it highlights the importance of that formulation I was talking about. So the expert being able to provide that full and detailed understanding of how this emotional dysregulation operates. So not just saying they have emotional dysregulation and therefore in that capacity.
Yes, yeah. And so utilizing a specialist assessor to ascertain the extent of their emotional dysregulation and whether it comes from, is a symptom of a diagnosis or impairment, or whether it is a freestanding impairment in itself.
But even if it is just a symptom, how that symptom operates, what are the triggers, all the things you've outlined. So it would need to be a mental health practitioner that does that assessment, right, in my view. Yeah,
that's very useful to know. Well, thank you, everybody, for attending. This was a short masterclass. I'll use the phrase that Aisling used. The weather in Manchester is great, so we'll keep it to that. If you have any suggestions of any future topics, let us know, but I hope you've all found this informative. And can I thank Dr. Todd for attending and giving us his very informative views, and Aisling also for giving your tour de force of the statutory framework and the case law. Thank you, everybody. Good afternoon, and hopefully see you soon.
Thank you.